Over the years, we have moved from a knowledge economy to a wisdom economy. And nowadays, we've got the opportunity to monetize our IP. With that said, there's a lot more awareness and conversation around what can actually be trademarked, what can be copywritten, copywritten, who knows what the word actually is, and how can we protect ourselves that we can grow our business or our own impact if we're a personal brand. But at the same time, there is not too much transparency around what's right, what's wrong. And we were just discussing the Katy Perry case last year. Can you protect your own name? What about brands like Apple? Can you actually trademark organic names like that? But this is exactly what we are talking today. And we are joined by somebody who is literally specialized in IP and trademark law. Donna Patene is our guest today. Donna, thank you so much for being here.
Thanks for having me.
I'm so excited about this conversation. We met last year at the Tropical Innovation Festival in Cairns. It was an amazing festival. And you were talking a little bit to business owners on trademarks, copyrights, patents and so forth. And I thought we're talking so much around frameworks these days and person branded based businesses. And there's so much confusion about what can you do? What should you do? What should you not do? I'm curious, you're specialized in start and scale ups and in the IP and trademark law. How did you get into that space? Because you are in hot demand.
I am now. It's been somewhat fortuitous timing because I started to dabble in IP law sort of 2007 into 2008 and 9, which is a great time to pivot out of property law because that's when the global financial crisis happened. And there was a trademark matter that came in, so I dealt with it. And then another one came in, so I dealt with it. And then sort of got involved with the startup ecosystem. So nowadays, there's kind of startup ecosystems happening in most big regional towns and certainly all the capital cities, where there's an organization that helps people start and scale their businesses and their ideas. And I got involved as a mentor and then providing, little speaking spots to help guide them from a legal perspective. And you can probably tell, or you will tell shortly, that I do speak at length if given the opportunity, because it's something that I really enjoy. And it is certainly an area that people, I think, know a little bit about, but not a lot about. So I like sharing some of that information so that it's sitting in their mind to think about at some point. So yeah, into it almost by accident, totally accidental and great timing. And then 12 years later, here we are.
And I heard you speaking last year, and I love how you simplify. Like for the normal business owners who don't necessarily have the law background, it is quite intimidating because you also don't want to get sued, but at the same time, you don't want to spend a lot of money, especially at the beginning, on something that may not be necessary. To kick us off, can you give us a bit of a lay of the land in terms of what is a copyright, what is a trademark, what is the difference between all of those legal protections?
Yeah, this is a great place to start because usually it's how I start either a presentation or a conversation, with a potential client. And I like to start with saying, look, IP is something that people know of, but not necessarily what the details are. So IP, or intellectual property, is the umbrella term for 7 different types of rights at law. And those rights are patents, trademarks, designs, copyright, confidential information, plant breeders' rights, and circuit layout rights. So when we talk about what is the IP of a particular business, we go through that list and work out, do we have patents, trademarks, designs, copyright, confidential information, plant breeders' rights, or circuit layout rights? And which ones we have. Not everyone will have all of them. And some businesses will have more of some on lists than others. Typically, almost every business will have a trademark or something that they're using to identify their business in the marketplace. But it's not that IP equals a patent for an invention. That's sort of the traditional starting point. And certainly that's one of the items, but it's one of those 7. So if we look at what is the IP of a particular business and go through those, I suppose just sort of 101 them a little bit. A patent is a registered right for typically an invention, a physical item that's usually a bit complex in terms of what it does and how it works. Then there's trademarks, which is your name or logo or device that you're using to identify your business in the marketplace. So we know the Golden Arches is Macca's. That's their trademark, and they use it really well and consistently, and we know what we can get there. The next one is designs, which is kind of the poor cousin to patents. So a design is a registered right for something that looks unique in its ornamentation. Really, that means it kind of looks cool on the shelf or on the floor. So it works well for furniture, for fashion, a lot of fashion, but also for things like fishing equipment or, different office equipment. So anything that's physical but has a unique look. There was a case I wrote about a couple of years ago about a ceiling fan. So lots of things can be in the designs register. And that process is quite a bit cheaper and still as effective as patents. So, but the poor cousin. Then there's copyright. So copyright probably affects everyone, and in particular the types of clients that you deal with, Petra, because it covers anything that is the material manifestation of an idea. So once you have an idea for a program or a movie or a song or some choreography and you put it down on paper or on the screen, even apps, so apps, the user interface of an app and things like that, once it's been produced in that format on paper or on sort of screen, it's automatically under Australian law protected by copyright. So that's a great free one that pretty much everyone gets. The next one's confidential information or trade secrets. So that is, what is it as part of the process that you offer that's your secret, your trade secret? So only you know that it works well or has this particular outcome for a client because of your experience and your background and trial and error usually. So all of that process and learning builds up and becomes your confidential information and your trade secrets. And that's best protected by contracting. So accessing limiting who has access to the information. Then after that, and I always put them on the other hand, is plant breeders' rights, because they're not as popular, but you can get a registered right for a new variety of plant. And then the last one is circuit layout rights. And that's literally the circuitry of a board where you've put the different elements. Very similar law to copyright law, but affects the physical layout of a circuit board.
Oh, wow. Now, clearly there are a lot of moving pieces. And when we start from the very beginning, we're seeing more executives and entrepreneurs, or the ones who are, you mentioned this just before, the one who are in this manager or senior role, but not quite at the top, they are stepping out more into their own business. And when we start there, we register a business name, so we are good to go. Nobody can come after us. Is that right?
It's like I wrote the question for you. No. So this is a common misconception, but also the source of probably 80% of my trademark dispute work. Because when you start a new business and you jump onto ASIC and you register perhaps your company, if that's how you're structured, and then a business name, and you get your ABN, and you pick a name, and ASIC will do a little search of the register and be like, yeah, that name doesn't exist. It's fine, you can have it. But that process and that register isn't designed to protect you, and it's certainly not designed to give any rights in the name. Quite the opposite. It's designed to protect consumers, so that if a consumer has a problem with a business, they can search the ASIC register and work out who's operating that business and therefore who to make their complaint against or who to sue. So it's designed for consumers, and it's not supposed to compete with or replace the trademark system because they have different purposes. The trademark system and trademark registration is how you get national exclusivity of a name. It's a much more complicated process, a much longer process. The breakneck speed is probably around 7 months, go to woe, but that's the only way to get national exclusivity of the name. What's more, when you do a trademark application, IP Australia does quite different tests, and the standards that they apply are a lot higher than what ASIC is when they're doing a business names registration. So IP Australia will do 2 tests. The first is this name inherently distinctive? And that really just means, is it not descriptive? So I couldn't trademark Cairns lawyer because that's descriptive, and other people should rightly be able to call themselves Cairns lawyers because they're in Cairns and they're providing legal advice. You couldn't trademark Cairns bakery for the same reason. It's too descriptive. So I couldn't trademark Cairns lawyer, but I could trademark, and I have, Dripple Legal. I've also trademarked my name because they're unique. No one else really needs to use Dripple Legal in their course of trade because it's unique. So it's highly distinctive. And naturally, all marks exist on a continuum, right? So they'll range from entirely descriptive to highly distinctive. And where you sit, you've got to sit sort of the right side of the hurdle in order to get that past IP Australia and meet that first test. Assuming that's okay, the second test is there anything else on the register that is substantially identical or deceptively similar? So while ASIC is saying anything the same here, nah, all good. IP Australia is saying, is there anything the same, but also substantially identical or deceptively similar. So when, for any mark that's on the register, you get this moat of protection around the name, because not only will IP Australia kick back anything that's the same, they will also kick back anything that is too close or substantially identical or deceptively similar. So something that might be in the marketplace, and if they were to both be in the marketplace, consumers would be like, is that the same or are they related? So things like adding a word, changing a letter, using a different number, things like that will still mean that you're too close to an existing mark. Now, the problem is those two systems don't talk to each other. So while ASIC will tell you if you're too close to a name on the register, ASIC will not tell you if you're within the moat of something that's on the trademarks register, and vice versa. IP Australia won't be able to tell you if there's a name on the business register that is likely to be a problem. So it's really important. And typically that means when they sort of both find themselves in the marketplace, because we live in the world of the internet, and quite often someone will get a call or review for the wrong business and the issue sort of comes to a head. When that happens, the first thing we need to do is work out sort of who came first. Are they too similar and within this moat in terms of that comparison exercise? And then sort of where do we go from there? In the meantime, though, because those systems don't talk to each other, you've got to check both, but you've got to check both. But in doing that, think about the fact that we're not worried about if they're matching. You can't make a wee change to overcome the issue. If you're sailing too close, you should probably get some advice on whether or not it's going to be a problem. We usually call that a freedom to use type advice. Or at the moment, IP Australia's got I think it's a beta version of a program called TM Checker. And you can pop in your name and it'll do a check that's applying that sort of broader test. I've used it a couple of times and I think it's overestimating at the moment. Like, you get a lot of results, which can be a little bit overwhelming. But that's usually the big crux and the sort of most tricky area in terms of how the trademarks work.
Wow.
Yes.
So many intricacies. And speaking of overwhelming, it can be quite overwhelming, especially at the beginning. And you also mentioned you've got your own name trademarked and also the business name trademarked. What would you say, how do you go about identifying what kind of IP should you actually trademark? What should come first? What has priority, especially if we're a person branded business, like a lawyer, a dentist, a consultant?
Yeah, and your personal name your personal brand is just as important as your business brand. So usually I want to understand, firstly, the budget, because these things cost money, right? The budget. So if it's a startup on day one, we'll usually map out, let's try and do this part first and some other parts later, depending on the budget. But sort of best case scenario, I would say, is if you've got an existing reputation in your own name, you can trademark it, and assuming it meets those tests and whatnot. And typically, I mean, we saw last year with Katy Perry, even though it's your personal name and other people are unlikely to need to use it, what if someone does? And is that going to cause you a problem? So it's working out how much of a problem it would cause you or your business if there was someone else doing the same thing. And of course, getting on the register and therefore making sure that IP Australia is going to bat away anything that's too similar. So yes, for personal names, if it is really important to your business and people are buying because they're contacting Donna, they're not contacting Dripple Legal. Typically over time though, and certainly with my business, so I started really leveraging just my personal name because that's the one people knew in terms of who do I contact for IP advice. And I've been shifting to use the business name more often so people get used to it. And because I chose a completely random and made up business name, I've got to build the goodwill and the reputation in that name. So I got both registered so that I've got both covered should I need to take action in relation to either of them. And I'm ready so that when I build the goodwill in the business brand, there's a very clear registered protected brand that all that goodwill and value will attach to. And eventually, theoretically, it'll grow. And at some point, I'll be sitting on a beach somewhere and Donna Patene won't be doing the doing, someone else will, but they'll all be doing so under the Dripple Legal brand, which by then will have this nice amount of goodwill attached to it.
I love your strategic approach.
The short answer is like both.
But you know, it's so true because nowadays we buy from people, and with more AI and deep fakes and so forth coming in, people are looking for more transparency. And I think the last year, with all the verifications on, you know, Instagram and Facebook and so forth, people are looking for the real person. So having your
Absolutely.
personal branded name trademarked is actually a very clever idea. I've never actually thought about it, but you know, ta-da! I'm glad to have you on to shed some light on that. Now, the next big question is with signature frameworks, like, you know, especially in the consulting space, how you can differentiate yourself is to have a signature framework that you say, step 1 is this, step 2 and 3 is this. But with that said, it's often quite generic. First we assess, then we analyze, and then we amplify, whatever it might be. Like, this is very generic. Can we trademark a signature framework, and or should we be afraid of somebody else doing something similar?
Yeah, and this is certainly a busy space, isn't it? Because there's a lot of ways to skin a cat, I think that's the phrase. And some will be more effective than others, but you're dead right in that people want to engage with people, and they want to know who is doing the doing, and it's not some random bot or something. Even when I'm buying nowadays, if I check the website and I can't find the who, like, who is this? I get nervous about it. So when you're putting together a framework or a program and things like that, there will, and we go through those 7 different types of rights, probably not something that's going to be patentable, because it's sort of an intangible method, but trademarks are going to be really important. And you can trademark your name and the business brand, but you can also get a bit more granular about that. Perhaps a good example is Harry Potter. So you could trademark Harry Potter and the Philosopher's Stone, Harry Potter and the Chamber of Secrets. I can't remember them all, but you get the drift. So if you've got unique names for the different steps or categories within your program, you can trademark those as well to give extra protection. Then you've got copyright protection in the manuals or checklists or other bits of material that you provide as part of that process. It might be a report at the end of the day. All of those bits of paper or video or other content that you provide as part of that is protected by copyright. And copyright is nowadays a little difficult to enforce, because when you put something on the internet, people right click or they download and it sort of runs away. Probably the best thing to do there is sort of just to make sure you're using a watermark or pop your logo on the corner like you've got there, gold star, to make sure that if it is going out into the world, then the source is still on the content somewhere and people can identify that's where I should go for the originator of that content, just to support, you know, the copyrights you've got. And then you've got trade secrets. So there'll be a certain element of that framework that you put into the public so that people understand what it is and see the value. But then there'll be the granular content underneath, which is what they need to actually engage with you to access. If you're doing that one-on-one, or even if you're doing it via an online sort of subscription type model, there'll be an element of trade secrets. There'll still be an element of copyright protection. And then you boost all of that with contract law. So your terms of engagement, or the little button that people click to accept your online course, contains your terms of service or your user terms. And that's the contract between yourself and those customers. And it can say things like, you know, obviously, here's how you get access, here's how you pay me, and all that sort of, you know, essential details. But also, here's where the IP sits. Don't reverse engineer it, don't duplicate it. And it boosts those IP rights by creating a nice contractual right. So if someone does download all the content and then spin it up onto their own website, yes, you would send a demand saying breach of my IP, you've reproduced the trademark, the copyright, and you've spilled my confidential information. But also, breach of contract 101 is the terms of service that you accepted. So it makes that process and that demand more powerful. And if you really need to take that action further down the road, you've got a lot of options there to have it taken down and seek some damages.
Thanks so much for clarifying, because it's such a, not shady, but a bit of a misunderstood space. Because, you know, obviously there's a difference between trademarking the name. So trusted authority, for example, is trademarked. But what I've learned in the process of writing the book and so forth is that I can't actually trademark or protect the actual process to get there, because some of the steps is assess your strength. Now, I didn't invent that. It's just part of the bigger picture. Like, it's 5% of my IP. And, you know, this is a quite an intricate balance to strike. What is my own IP? And I was also talking recently with a futurist, and she said there's another futurist who's got the similar approach to reimagine what the future looks like and then work our way backwards. So in this case, like, we're not reinventing anything from scratch, but at the same time putting our own background experience and stories in there that actually makes up our IP. Is that right?
Yeah, and the way you deliver it. So the way you have presented the information, the way your engagement happens, and as time goes, the brand under which that's done. So I think my favorite example at the moment is those boxes of groceries that get delivered to your house. So they deliver the box of groceries, you get your little menus and you get all the ingredients and they're like ready to go in their little collections of how much you need. So there's HelloFresh. Oh, this is an interesting new concept. We haven't seen this before, but HelloFresh don't own the concept of we're going to put a bunch of groceries in a box and put it at your door. Here comes Marley Spoon. Here, I think there's like 4 or 5 of them now, all doing the same thing, because that concept or the process of put some groceries in a box and put it at your front door, here's the recipes, you know, sort of hit us how to make that dinner process easier for you. None of them own that process in particular, but they've got to put their own spin on what they're doing. Our recipes are easier or cheaper, although we really don't want to be fighting about price. And I think the winner will end up being the brand that's got the best reputation and goodwill attached. So if you've got customers saying, oh, my box keeps getting left in the sun, or such and such is missing from the box, just all those little things start to bring down the value of the brand. And even though we're all kind of probably doing the same thing, if customers are having a really good experience doing the same thing with HelloFresh and not others, for example, it's going to end up leading because of that brand goodwill and the value of the trademarks. So I think that's same but different, right?
It is, but you know, again, it shows the power of the brand, how you get your message across. Because I can say, sleep more, eat less, and exercise more. Like, it's not my IP, but I could still own that as my methodology if I was a PT to work with my clients, but I can't protect it. So to be really clear, what can we actually protect? So if I trademark something, if I have a copyright on something, what does it actually protect and what doesn't it cover?
So a trademark will protect the name or the device or the logo that you file, plus anything that's within that moat, substantially identical or deceptively similar, in relation to similar goods or services. So if someone decides to start up, I don't know, zinc sinks, they're probably able to coexist because they're completely different industries. So the trademark registration protects the brand in relation to those types of goods and services. And you can get more granular on that and create a name for your program, if that's the case, and protect it separately. So no one else can call their assessment program, whatever it is, trusted authority. They'll have to call it something else. Then the next level down from that is the content, protected by copyright. So no one can reproduce your templates, your checklist, your videos and whatnot. That's protected. But that doesn't mean that they can't create their own version. So if we've all decided that reef fish are really hot right now, we're all going to draw a picture or a painting of a reef fish. Everyone's got the same idea of drawing a picture of a reef fish, but they'll all independently draw their own version. And some people will like Nemo and some people like Dory. And some people might like Nemo, but they think he should be bigger or smaller or fatter or more stripes. And the output will be all completely independent. So long as you didn't see someone else's fish and then copy it and try and tweak it, that will still be an infringement. So if someone has access to your content and then copies it and tries to tweak it, if the essence is still there, it's still hitting the main points, it still looks very similar, it will you'll still be able to take action. But if they've independently created the same type of process because it works, then there's no action there. So certainly there's a certain level of protection you can get by protecting the name of your business, the name of the process, if you've got a cool name for it, and then the content itself as it appears. Beyond then, it's a little bit of a free market. So you've really got to make sure that you're leveraging your brand so that people know they want your version of this program, which contains this, and not someone else's.
I'm glad you mentioned it, because so many are also afraid of getting sued because somebody said, oh, somebody else talked about this topic already in this way. And this is also my experience. Yes, it is, but you've got your own stories, you've got your own word bubbles, and the language that you're using is different, and your audience might also be different. So it's not.
And the delivery will be different each time.
Yes, absolutely. Now let's throw in the spanner with ChatGPT. Like, where's the line between what ChatGPT spits out, between my own IP that I thought of 10 years ago? What can we protect?
Yeah, the every answer to everything in this space is it depends. We don't know. Wait and see. So at the moment, and our friends in the States are doing most of the litigation in this space. So we're relying heavily on what the outcomes are over there to let us guess where things might fall over here, because the issues are twofold. The first issue is what's going into ChatGPT or any other AI program. What are they using as the data set to inform the decision making that's happening, under the hood? And there's been some litigation with Getty Images and a few others where the images are being drawn in to train an AI model, which is then spitting out results based on those images. And the courts have said the drawing in of all those images and scanning and using them to guide the AI program is a breach of copyright, because you don't have consent to reproduce all of those images. You haven't paid for them. There's no license there. Not like you went through and bought all the stock images from Getty Images, and that would cost a whole heap. So there's an issue there in terms of what is the system bringing in, and is that infringement? And the courts have also said an AI system is not a human, and so can't be liable for infringement. So the Getty Images were suing the creators of OpenAI. Then on the outside, sort of what is the output? For the same reason that AI is not a human and can't be liable, AI doesn't create IP. So pretty consistently now between the US and Australia and the UK as well, the courts have said, because AI is not a person, it can't own the copyright in the outputs. And the output has to have a certain level of human intellect and effort in order to get, for example, copyright protection. So most of the output of an AI program will be something that would usually be protected by copyright if it was a human, because it's either an image or it's, some words or whatnot. But because it's not a human, it can't own it. So there's been one particular artist in the States who's been testing and saying, so what if I've been putting in the prompts? So I put in the prompts to tell it what to spit out. Is that enough of my human effort to make it tick over? And continues to create more detailed prompts or a longer chain of prompts to say, well, is that enough effort? How about now? How about now? And it still isn't hitting the bar. So far, we're still sitting at no, if the AI is really the one that's actually producing the ultimate outcome based on this content that's within it and guiding the AI, no, not enough human input there. The latest I heard on this was that he had drawn a really like a sketchy pencil, dodgy looking drawing and put that in as the initial prompt to say, well, if I've started with a human created piece of art and then I prompt it to update it, will that work? And we're yet to hear what the outcome is on that. So at the moment, anything that's created just by you popping a chat into Dolly or, any of those image creator ones, even Canva's got a system, I think, no one will own the copyright because it's created by AI and AI is not a human.
Excellent. And I think it will only get more complicated with more access to AI tools and who did what and when and how.
Yeah.
But it's, a good distinction. It's not a human, so we can't sue technology, at least not at this stage.
Yeah, you certainly stay tuned because it's a moving feast for sure.
It is a moving feast. Now, how do you help your clients identify what should actually get trademarked or protected? Because in a business, there are so many moving pieces. Is it the ideas, the concept? If it, how do you go about that?
So I like to understand what's the important part. What's the important part? And of those 7 different types of rights, which ones can we use to make sure we lock down that important part? Because there'll be elements of the business that kind of incidental, and if someone reproduces that part, I'm not particularly worried. Certainly the main brand of the business will usually protect. And if there's a potential problem with those 2 tests that IP Australia does, is it distinctive and are there any prior marks? We'll group it together as a logo because a logo will be more distinctive, but preferably doing just the business name gives you the best bang for buck on that, and best position if you need to enforce. Also looks great on a pitch deck. Any of the above looks great on a pitch deck if you're going to, for investment. And you say, I've thought about IP. Here's where I'm dealing with, trademarks, copyright, et cetera, et cetera. It looks great on a pitch deck. So I always the main brand. Then we talk about, is there a trade secret or a confidential aspect that we need to think about locking down? How do we do that with our contracting? Let's look at our contract, because quite a lot of businesses I find will have a great idea for the industry they work in, usually automating something, and so there'll be a sort of a technical aspect to it. and they don't necessarily have those technical skills. So we'll outsource to a developer to create the technical aspects, for example, an app. Because they're a contractor, the contractor technically retains the copyright. So let's look at that agreement and make sure we get the copyright assigned over, and then we get access to the back end and, login details just in case, the friendship sours. Sometimes that happens. Then we talk about what else in the program or the solution that might be just sort of the implementation of an idea. So it might be a process for something. We might not be able to patent the process because it's sort of just business methods or almost business as usual. We're just dressing them a particular way. What can we do to turn that into something that's able to be monetized? Can we give it a unique name? And in particular, can we give it a name and then as time passes, make that a bit like Apple does, a 2.0, a 3.0, a 4.0, so that the marketplace knows if you've got or you've done course, Banana 2.0, you're out of date, man. We're up to course Banana 4.0 to get them coming back and upgrading and refreshing and making sure that you've got something clear and progressive that your consumers can see. So sometimes there might be a series that you can do. So you can file what's called a trademark series. And if there's something within that process that we can give it unique names and so that we can put out to the marketplace, we've got series Banana. By this, I'm really bad with examples. I don't come up with the brands, I just protect them, okay? I'm not creative. And use the main brand, which is the provider of the Banana course, and you want to make sure that you've been doing the Banana course. Hey guys, we've updated our course. It's now the Banana 2.0, and use a lot of the trademarks, because trademarks are relatively inexpensive to do, to make sure that we're making it clear to the marketplace that it might be a program that other consultants might provide, but it's the Banana course and you don't want some other course. You want the Banana course because that's what everyone's talking about and that's what everyone's had their good experiences with. So that's probably the main aspects that I'd usually go for.
It's, yeah, absolutely. Like it's such again, I love your strategic approach to it because there are so many moving pieces. And as a business owner, when you are in the trenches and do the finance and the marketing and the selling and the development, you're like, I don't know where to even start. So clearly everyone needs to get in touch with you, because in the second you put a third party or any kind of agency or any other, consultancies in the mix, it's a completely different ballgame. And we were involved in an agency coming up with a name, but then we found, so as the client side, we found that somebody else 6 years ago had used it. It's an inactive account, but we're like, oh my God, we need to trademark everything. And but you can't rely on anyone else, because in the end, and correct me if I'm wrong, but you as a client, you're still the one responsible, not the third party for any lawsuits or whatever it might be.
Yeah, because typically if you have, and this has happened before, if you have paid, say, a developer or some other external party to create some sort of content, and then the content goes on your site, so technically you're putting it out into the marketplace, you will get the demand from the owner of the copyright or the trademark. Yeah. And you might, well, depending on your agreement with that contractor, you might have a right of indemnity. So if you are sued, you then recover from the contractor, but that's a whole secondary process.
Yes.
Yeah. Clearly, prevention is better than cure.
Yes, and clearly we need to get in touch with you and have you looking after all our legal issues and questions. Donna, where can we find you, learn more about you, connect with you?
So, certainly you can follow me on LinkedIn or connect with on LinkedIn. That's where I usually do like my worky blah blah.
The technical term for it, I guess.
Yeah. The other places are obviously at Dripple Legal on Instagram, Facebook, X, which is not Twitter anymore, which is a whole other thing, and LinkedIn, and also TikTok. I got the handle on TikTok, but I haven't done anything on there because I'm way too old for TikTok, I think. But time will tell. So at Dripple Legal on all those places, or simply drop me an email, donna@dripple.com.au.
Perfect. Well, I'll definitely put all the links in the show notes, because I think nowadays we have to protect ourselves more than ever before. People want transparency. They want to have the stamp that somebody is legit in what they're doing. And, I cannot recommend you any further. So thank you so much for being here, sharing all your wisdom, and also making law fun, which is unheard of.
It's a tough topic. Yeah. Thanks for having me.
Thank you.